All right, so just in recapping, who are the main parties to a trust?
The settlor, the
The
trustee, and the beneficiary.
beneficiary.
Okay, how do we terminate a trust? Just off the top. Just your understanding of how it's terminated.
The trust can be terminated if all the assets has been disseminated or like if all the assets have been gone.
Right? That's the income and the capital. What else? We have a case that is important in determination.
Flanders versus Voltaire.
Yeah, what that rule tells us.
If all of the beneficiaries who are of sound mind and age, if they come together and they decide that they want to basically do away with the trust.
Right. But what's important about that? Because they could come together, but what must happen? What has to happen for them to come together? How will they be able to terminate?
You mean that they can do it legally, request that it be, the title be, for the property be transferred over to them?
Right, but what they have to be entitled to in order to do that? What has to happen? Why, how they'll be able to terminate? Because anybody, that means any beneficiary could come together and terminate the trust, but what that means, you have to be both what? What is a beneficiary in the trust? He's a what? What kind of owner is he? He owns the what?
Mm.
The trustee is the, what type of owner is the trustee? The trustee is the legal owner? Do you remember that?
The trustee manages the trust. They're not the
So,
legal
but
owner.
he's the,
The legal,
legal owner because all the documents are in his. Trust is a law of equity. Remember when we said the trustee only holds it for the benefit of someone else? He's the legal owner, but the beneficiary is the equitable owner?
Yeah.
Anyone from last week? That rings a bell?
Yes, ma'am.
Okay, so the beneficiary has to be entitled to both the legal and equitable interest in the trust in order to be able to terminate the trust if he is of sound mind and legal age. If he is entitled to both equity and legal interest, which means he is fully entitled, wholly entitled, then he can terminate the trust at any time. When they come together as a group, what has to happen in order for the rule of Sanders and Vautier to apply? Remember, we talked about properly ascertained and complete as a group and beneficially entitled to the trust property. And it cannot apply in the case of Sanders and Vautier cannot apply in the case of what?
Of unborn beneficiaries?
Right, who are not or unascertained or unascertainable beneficiaries. You can't apply it. What types of express trust we have?
Non-discretionary / fixed interest trust, discretionary trust, part discretionary, part fixed interest trust, revocable trust, irrevocable trust.
Okay, and what is an express trust?
An express trust is a trust that is established intentionally and explicitly by the settlor who transfer trust property to the trustee with instructions as to how and for whose benefit the property is to be managed and administered.
Okay, and what we say about, who's the object of the trust?
Oh, you was breaking up, so I didn't hear the question.
Is the object of the trust? You heard the question?
No, ma'am.
Okay, let me see why I am not. Who's the object of the trust?
Who's the object of the trust? Would that be the beneficiary?
You heard me? Right, who's this, what's the subject matter?
The subject matter.
You're talking about the corpus?
Right, so corpus on, what would we call it, the what?
Subject matter of the corpus.
What would we call it, other than the corpus?
The subject matter? No, sorry. Trust instrument.
What the corpus is, huh?
The corpus is
What the
another term. Would that be trust instrument?
It's the trust property, eh? Remember, this the trust property, which is the subject matter, whatever is put into the trust. So the corpus usually is all the trust property that's put in initially, eh? And how do I declare, what is another certainty I need to have? Certainty of what? I have certainty of object, certainty of subject matter, and certainty of what?
Intention.
Yeah, and how do I express my intention?
I say, I declare myself to be the trustee.
So it has to be in words that specifically state you clearly intend to create a trust, eh?
Mhm.
So we create a trust by what we just said. How do we create a trust?
We
Y'all are
create
hearing me?
by ensuring that the three certainties exist.
So that's in order for it to make sure it's a trust, but how do we start it? How's a trust created?
Well, the settlor declares himself a trustee for an intended beneficiary.
Right, or
By the settlor transferring the property to be held in trust to the trustee, thereby constituting the trust.
right, and those three certainties must exist for the trust to be satisfied, right?
Yes, ma'am.
So we create the trust and the three certainties must be therein in order for it to be satisfied. Who's the regulator for the trust? Which agency is the regulator for trust?
Central Bank of the Bahamas.
Okay. And what laws govern the trust? We have just given me two.
Repeat that question, please.
Which laws govern trust in the Bahamas? I just need two.
The Trustee Act of 1996,
98.
98.
Give me another one.
Trustee Amendment Act
The Bank and
2011.
Trust,
Okay, we got two years now. We got the Trustee Amendment Act 2011 and the Bank and Trust Regulation Act. And give me just two duties, general duties a trustee has in equity.
To get trust property into the trust and to familiarize himself with the trust instrument.
Okay. Excellent. Now, we did unit 1 and 2 last week, eh? Or just unit 1?
We just did unit 1.
We did the introduction and chapter 1, unit 1.
Okay, let's do 2 and 3 today. I thought we had done, I just realized we did 1 and the introduction. So we'll start with unit 2. After completing this unit, we should be able to define the parties to a trust, describe the key roles, duties, and responsibilities of the parties to a trust, consider the legal requirements relating to a trustee's duties, and understand the relationships of the parties to the trust. So we'll begin with the set law. And we have Chevial Gibson up first.
Hi, good morning. Sorry, I did not pick up my material as yet. So, yeah, I've already, I'm just observing today, but I'll catch up by next session.
Thank you.
Thank you.
Dominique Roberts is next.
The settlor. The settlor, who is also referred to as the grantor or donor, is the person who originally has legal and equitable title to property and transfers assets into a trust for the benefit of another person or persons.
So sometimes in the trust document, we may have persons being called the grantor or a donor. So it wouldn't be different. You just may have a different name. And we know the settlor is the one who initially owns everything and he transfers it out. Go ahead, sorry. Dominique?
Yes.
You could pause after it just in case we just do a little explanation for everybody, okay?
Okay.
Thanks.
In instances where a trust is created in a will, the settlor will is referred to as the testator or testatrix. If it is a woman creating the trust in the will. A trust is an inter vivos trust, where a settlor creates a trust during his lifetime, and a testamentary trust, where the trust is created in a will made by the settlor.
So this would be talked about last week, where we said the trust may be created during your lifetime, which is an inter vivos trust, or it may be done upon your death, where you would now become a testator or a testatrix, depending on whether you're male or female. So usually in the inter vivos trust, the settlor is setting up the trust during his lifetime, and he may also become a what? What he may also be on the trust. What we say last week, the settlor could also be a what?
A beneficiary?
A beneficiary. Remember we said he can also be a beneficiary. Y'all can hear me?
Yes, we can. Well, I can.
Remember I said we have to participate now. So y'all could just say yes or no, or just at least chip in. So I know you all are there. So I'm just asking you if you remembered from last week that we said the settlor can also be a beneficiary.
Yes.
Okay. Go ahead.
The legal interest in the assets is transferred to the trustee, who becomes the legal owner, and the equitable interest is transferred to the beneficiary, who becomes the equitable owner of the assets.
So that's what we just went over. Who's the legal owner is the trustee, and the beneficiary is the equitable owner. Go ahead.
Notwithstanding the fact that the settlor may be the client of a professional trustee who is responsible and contracted to pay the annual fees of the trust. Once a trust has been created, a settlor has no rights regarding the trust unless he has reserved such rights in the trust instrument, as in Section 3 of the Trustee Act 1998 and the Trustee Amendment Act 2011.
So therefore, the settler has no rights unless he reserves those rights in accordance with Section 3 of the Trustee Act or the Trustee Amendment Act 2011. So before this wasn't available to the trustee, he couldn't reserve certain rights to himself, but now he can reserve those rights because once he transferred the asset, he had no more say before, right? Right?
Correct.
Okay, go ahead.
Therefore, the settlor cannot vary or modify the terms of the trust, appoint trustees, remove trustees, exercise discretion on the payment of trust fund, or terminate the trust unless these powers have been expressly reserved within and directed by the trust instrument. The settlor may issue letters of wishes to the trustee, which in effect stipulates his wishes in relation to how the trust should be managed and administered. However, though the letter of wishes provides practical guidance to the trustee, it is not legally binding and is not required to be followed by the trustee.
So the settler will issue letter of wishes because otherwise, you have no idea. This is the settler is a stranger. The beneficiaries are a stranger to you as a professional trustee. So this is a guide for you to be able to understand better the relationships and how the settler may have wanted you to use your discretion in the case where you have a discretionary trust. So usually they give a letter of wishes when there's a discretionary trust where the trustee has to use his discretion. They give you a letter of wishes. It's not legally binding, therefore you cannot use it as evidence that you are following his wishes because you're not supposed to be following his wishes, but you're supposed to be using your discretion because then it seems as if you're a puppet for the settler and the trust wishes is only guidance for you to be able to understand better how the relationship works and how you should use your discretion in making decisions, basically in distributing or making any investment decisions for the trust. Go ahead.
A settlor may have certain rights under law as a beneficiary. Example, the right to information under Section 83 of the Trustee Act of 1998 of the trust, but only in his capacity as a beneficiary. The settlor does have certain contractual rights based upon his client agreement and the professional trustee. Example, confidentiality, professional care and skills, etc. However, as it relates to the trust itself, it should be noted that only the beneficiaries may sue the trustees for any legal breach, including a breach of trust.
So the settler's right is only extended if he's a beneficiary, and that's a right to information as set out under Section 83 of the Trustee Act. Otherwise, he only has contractual rights, that is the right to confidentiality and professional care and skill of the trustee who he's employee. But as to the trust itself, he has no rights unless he reserves that rights under what? How can he reserve his rights?
Under the information section 82 of the Trustee Act 1998,
What is it? What section?
83 of the Trustee Act 1998.
That's if he's a beneficiary. Where can he reserve his rights as a settlor?
Within the trust
Oh.
agreement?
We just read it. We just read it,
You mean within the trust agreement?
Would that be
right? But
section 3 of the Trustee Act 1998 and the
Yes,
Trustee
that's-
Amendment Act 2011?
right, he could reserve those right under that section 3.
Okay.
That's where he can reserve his rights to do certain things. Because then it'll be like it's a settler directed trust. That's where he'll be able to modify the terms of the trust, appoint trustees, remove trustees, exercise discretion on the payment. So that's where he's able to do those things. Otherwise, he's not supposed to be involved in the trust. Okay, go ahead. Who can sue for breach of trust?
The beneficiaries.
Right, only the beneficiaries, eh? Go ahead.
The settlor may act in the capacity of a protector, an individual executive entity with the responsibility to oversee and supervise the actions of the trustees, and in certain instances, provide his consent under the terms of the trust instrument. He may also be considered a power holder in his capacity as a protector, which has certain implications to the trust.
So who's a protector?
An
The
individual.
settlor,
What, sorry, yeah?
Who's a protector?
an individual executive entity with the responsibility to oversee and supervise the actions of the trustee.
Okay, and who may be who may be a protector?
The settlor,
Yeah, so the settler can also act as a protector.
Also, wouldn't a protector also be like a close friend of the family that the settler might feel confident in?
He can be, because then he'll be able to speak with him, or he may hire a professional person to be a protector who he has confidence he can give directions to.
And that is also someone that a trustee can actually go to if it's set up in a discretionary trust, that if they're not too sure on, let's say, a beneficiary were to come and request a certain amount of funds, and they have to use their discretion with along the letter of wishes, they could go to the protector and say, in the scenario where the beneficiary came to them for a certain amount of money, they could ask the protector as well for their discretion.
Right, so remember the discretion, what we say about the discretion of can he throw that discretionary power discretion, he can't send that off to somebody else to use, eh?
Okay.
Only the trustee can use his discretion. So what the protector may say is, basically, I don't consent to you making that distribution at this time, because his consent may have to be given in order for you to do certain things. So as much as the beneficiary approaches the trustee still may require the consent of the protector to make the distribution. So his discretion doesn't come into play. The trustee's discretion, that's his own, and it's reserved to him only. He can't pass that on to someone else. But his powers to make distribution may require the consent of the protector to do so.
Okay.
All right, go ahead.
Under Section 13 of the Trustee Amendment Act 2011, TAA, which inserts a new Section 81A into the Bahamas Trustee Act 1998 for settler-directed trusts in relation to investment powers, a trustee may be absolved from any liability for loss to the trust where he has acted on the instructions and or directions of a power holder or failed to act in the absence of a direction from a power holder with responsibility for investment.
So this is where we have settler directed trust. And what it is the investment powers have been reserved to the settler, and they're called now a power holder. So basically, those powers are no longer for the trustees to take into, they're not under the trustee's portfolio. And if he doesn't act on, or if he acts on the direction of the power holder, or he fails to act where the power holder has not given him any direction for investments, he will not be held liable because that's not under his portfolio. That power has been reserved to the power holder or the settler in this instance. Failing to do something or taking instructions to do something that would have harmed the trust. In this instance, he is absolved from liability because those powers have been given to a power holder. Okay,
Under the provisions of
last part.
Under the provisions of the TAA, a power holder is defined in Section 18 of the Act as any person holding a power in relation to a trust, including a power of appointment, consent, direction, revocation, or variation, and any power to appoint or remove trustees or power holders, and includes a person in the position of a protector.
So this power holder can also be the protector. And you see they have a lot of powers. They can appoint, they give consent, they give directions, they can revoke the trust, they can vary the trust, or they can remove trustees or power holders in this instance. So they're given wide powers. And they're defined under Section 18 of the Trustee Amendment Act 2011. Any questions on the settler's information? No? Okay, we move on to trustee. Olivia, you're next. I think Dominique just read for us, so it's Olivia.
A trustee is a fiduciary, which is one who is placed in the position of trust and confidence and acts on behalf of another person or persons. The fiduciary owes certain duties of loyalty to the person or persons for whom he or she is acting. Additionally, a fiduciary should act in good faith in relation to the person or persons for whom he or she is acting.
Go ahead.
As a fiduciary, a trustee is prohibited by law from profiting from their position as trustee. He must not place himself in a position where his duties to the trust conflict with his personal interests. However, it should be noted that a trustee may not be remunerated for his services unless authorized by the trust instrument and or the court allows him to be remunerated for a fair and just amount for his time and effort in administration of the trust. Foster v. Spencer, 1996.
Okay, so as a fiduciary, you're placed in a position of trust. Therefore, you should not allow your personal interests to conflict with your duties. So you shouldn't put yourself before the person that you have placed yourself as a fiduciary to act in their best interest. So when your personal interests and your duties conflict, you should move away from the situation, eh? Or at least disclose that there's a conflict and allow the person to decide if they want to continue with dealing with you. So if you as a trustee purchasing a property and I find out, well, you're purchasing the property, you offered $10,000 for the property. I'm interested in the property as well. I have information based on my duty as a fiduciary. And I go up behind you and place a bid on the property for 11,000. Am I conflicted? Y'all can hear me?
But, can you repeat the question, please? No, the internet dropped just now.
Okay, I'm saying to you, the fiduciary, y'all heard me describe the fiduciary?
All right.
Can everybody hear me or no?
I can
Yes,
hear
I
you.
can
but
hear
you
you.
have to
I can hear you.
Okay. You know what I did not do is take the register. That may help me to know that everybody's here. Let me do that before we move any further. Okay, I have Cheval Gibson. Just pronounce your name properly for me instead of me murdering your name.
That's fine. Cheval or Chevelle. That's it. Chevelle is fine. Chevelle.
Okay, Cheval Gibson.
Yes, ma'am.
Okay, Monique Mitchell, Olivia
Yes, ma'am.
Ferguson,
Yes,
Yes.
yeah.
Dominique Roberts,
Yes.
Kendra Jones,
Yes.
Daniqua Major, Okay.
So Nico Major just answered in the chat. I don't think she has I think she has problems with a speaker or something.
Okay. Okay, so we have to have a forum in order for her to participate in the class. Okay, let me go to the chat to make sure we are up. Okay, yeah, we can't hear you, Daniqua. You probably have to get your speaker. I don't know what it is because it's not working. Chrisia Ambrista.
She's here. She's in chat as well.
She's in the chat now. She said, yes, I'm here. I think you can't hear me. I may have to log out and log back in.
All right, Shanice Rule.
Here.
Okay, Tanisha Knowles.
Yeah.
Okay, did I miss anyone? 1, 2, 3, 4, 5, 6, 7, 8, 9. I only have 9 persons present. Let me make sure. 2, 2, 4, 6, 8, 9. Yes, only 9. Okay then. All right, I'm just making sure. So I have silence with Doniqua and Crasiria. So they'll just answer in the chat to participate. Okay. So the fiduciary, we're saying that the fiduciary should not allow his personal interest to conflict with his duties. Where there's a conflict, he should disclose such conflict to whomever he's acting as a fiduciary for. So I'm drawing an example that if the fiduciary is purchasing a property on behalf of the trustee bid 10,000 on the property, the fiduciary uses that knowledge to say, I'm also interested in the property. I'll bid 11,000, 1,000 higher than the person I'm acting on behalf of. Is that a clear conflict?
Yes, it is.
So in that instance, he should move away from the transaction or disclose it to the other party and let them give the okay that they're not, that's fine.
He should move away from the transaction.
Right.
But didn't you also say that he would just have to disclose the terms of the arrangements?
Right, he has to disclose it, but now if he's disclosing it and it's still, he's only found out about this information because he was in his capacity as trustee. So if he purchases it without knowledge to the beneficiary or whomever he's acting on behalf of, what happens with the property that he purchases? He'll become like a constructive trustee for the beneficiaries because he was only able to purchase the property basically on his promised position as trustee. He got more or less inside information and he used that to his advantage to outbid the trustee, and he would have been able to obtain the property as a result thereof. So in instances where there are duties conflict, they have to disclose it and or just be conflicted where you're trying to do the same thing as who you're supposed to be acting on behalf of.
My thing blocked out just now. My internet dropped a little. My question is, who would they be disclosing to? Would they be disclosing to the beneficiaries?
So you would disclose to the beneficiary or protect in that instance to say,
Okay.
well, you see, that's where it becomes discretionary power over. And you think now the beneficiaries are gonna say, well, yeah, that's no problem. Go ahead and do it for your betterment and to our detriment?
No.
No, so it would be easier for him to not deal with that transaction, eh? Because his duty comes first and not his personal interest when he is a professional trustee and a fiduciary. Yes?
Yeah.
Correct.
Right. All right. Next.
Okay. As the legal owner of trust property, he has certain duties and obligations in relation to the preservation and protection of the property and in relation to the beneficiaries on whose behalf and for whose benefit he holds the trust property. The trust
Go ahead.
is the trustee?
Yeah, the
The trust-
trustee.
The trustee may be appointed by the settlor in the trust instrument at the creation of the trust during the trust to replace a trustee who has died, resigned, or been removed, or by the beneficiary and or court under certain specified conditional and in some exceptional circumstances. The trustee of a testamentary trust by appointed under the will of the testator will essentially take effect on the death of the testator. Once appointed, the trustee will be required to act in accordance with the trust instrument and trust
So the
law. Hi.
Go ahead and you continue, finish it.
With the trust instrument and trust law in general as developed by common law cases as statute, Trustee Act 1998. In the course
Okay, go.
You want me to pause?
Sorry. Go ahead. No, go ahead. We'll recap it when you're done.
Okay. In the course or administration of the trust, the trustee will be given certain duties and powers. He obliged to perform his duties under the trust in accordance with provisions of the trust instrument, but he may use his discretion in the exercise of powers under the trust, if at all. Whatever the case, The trustee must act and exercise his discretion and decision-making powers in the best interest of the trust and an equal and fair treatment of all beneficiaries.
Okay, so the trustee is appointed by,
The said law,
right, at the creation of the trust, or he may be appointed when he's being replaced by, when he's replacing a trustee who has done what?
died, resigned, or been removed.
Okay. Or the beneficiaries and or the court may appoint trustees under certain conditional or in exceptional circumstances. So we'll get into that more when the court or the beneficiaries may say, you're not acting in our best interest. What would you think that'll be? Which case that'll be in? Would we just draw an example of? His duties is conflicting with his personal interest is conflicting with his duties. So when we see you acting in your best interests and not in the best interest of the trust, we'll approach the court as beneficiaries to sue you for breach of trust, eh?
Right.
And we're asking the court to replace you because you're not acting in our best interest. He also the trustee can be appointed by a testamentary trust, which is a trust created by what? What the testamentary trust is, the trust created by what?
The testator,
By the will of, and so the
By the will.
testator, right. So the testator or testatrix would have appointed him as their trustee. Okay. He's obliged to perform his duties under the provisions, and he can use his discretion in exercise of the powers of the trust. If at all, doesn't mean he has to do it if he doesn't want to do it, because he has a what? What he has?
A conflict?
He has discretion in making decisions. And he is to act in the best interest of the trust and in equal and fair treatment of all beneficiaries. So he can't favor one beneficiary over the other. Okay, the general duties.
the general duties that a trustee has in equity are: 1, to get trust property into the trust. 2, to familiarize themselves with the trust instrument. 3, to administer the trust in accordance with its terms. 4, to act in a fair and impartial way to the beneficiaries. In other words, he must treat all beneficiaries fairly and take into account their respective needs. 5, while the trustee is not under a duty to distribute the income or capital, he must consider whether to distribute the income or capital on a regular basis. 6, to keep trust accounts. 7, to provide the beneficiaries with information in accordance with the trust instrument and or applicable trust law. 8, to exercise reasonable care and skill in administration and management of the trust. 9, to invest in investments authorized by the trust instrument and applicable trust law. 10, to protect and preserve trust property from unnecessary loss. 11, to act in good faith in the best interest of the trust. And lastly, to make no secret profit.
So he shouldn't, all of these things are general duties. This is not the extent of the duties, it's just generally. So he has to ensure that he acts in good faith in the best interest. He shouldn't make a secret profit. Basically, the only way he's making a secret profit if it's a secret profit as a result of him being a trustee. He must keep the trust accounts, act impartially towards all of the beneficiaries. He must administer the trust in accordance with its terms. He must familiarize himself with the trust instrument, so he should know what he's doing, because the trust instrument gives him directions. And then provide the beneficiaries with information in accordance with section 83. They have a right to information. exercise reasonable care and skill as that of a prudent man in any one of their affairs in the administration and management of the trust, and to invest in investments authorized by the trust instrument and not otherwise. And he must protect and preserve the trust property from unnecessary loss. So he shouldn't allow the trust property to fall into disrepair. Go ahead.
The trustee may delegate certain duties to another person if the terms of the trust instrument allow him to do so. However, he may not delegate his discretionary power to distribute to a beneficiary, and he may be liable for loss suffered by the trust due to the reckless and negligent actions of the agent to whom he has delegated his duties, if he did not take proper care to appoint or select the agent properly and supervise him adequately.
Okay, so you see what we say, he can't delegate his discretionary powers. Remember I said that earlier? So your discretion is your discretion. You can't delegate that to someone else to do, to distribute. If he appoints an agent, he's delegating his powers or his duties, what he should do, properly what? He shouldn't just give him the duties and then not supervise him, eh? He should ensure that he's what he's supposed to do. Exercise reasonable care and skill in the administration and management of the trust, and protect and preserve trust property from unnecessary loss, eh?
Yes, ma'am.
So in all what he's doing, his duties should always be paramount. He should also always take these seriously and do what he's supposed to do. All right, any questions on the trustee?
Yeah, I have a question. In the capacity of a trustee and in terms of like breach of contract or lack or care of duty in carrying out the terms of the trust deed or document or whatever it's called, can, like, let's just say if there was some malfeasance that was conducted, would the beneficiary sue for wrongful or poor administration, like sue a firm or sue the actual individual trustee, person
So
who they,
remember, okay, so initially we can have individual trustees. They have certain limitations, or we have trustees that are corporations. So in the instance where it's a corporate trustee, you have to sue the trust company itself, because those persons are not acting as individuals. They're acting in their capacity as a member of that company. So they may be employees of the company, or they may be directors. But in certain instances, we have trust companies over here. We have Scotia Trust, we have CIBC Trust. Those persons are only employees of those companies. So you won't sue those individuals because they are employees and they are acting in their capacity as employees of a professional trustee, because Scotia is selling their services or CIB selling their services as a professional trustee. So their due diligence requirements should be that they ensure their employees are properly trained and understand the intricacies of acting as a fiduciary and a trustee. So the beneficiaries won't sue the individual, they'll sue the trust company. If they are individuals, they'll of course be high net worth individuals, and they will sue them as a group because they came together as a group to act as trustees.
okay, thank you.
Okay, now we go on to beneficiary. Any other questions on trustee?
Mute. Start.
Okay, so we go next to Daniqua. Is your mic working yet? Okay, Dominique Roberts, is your mic working?
Yes.
We can't hear you, Doniqua. No, we can't hear you, Doniqua. Okay, so Dominique, we'll start with beneficiary. No other questions on trustee? Okay, say it again.
I'm saying no question.
Okay, beneficiary, Dominique.
Beneficiary. The beneficiary is the person who has the equitable interest in trust property and on whose behalf the trustee acts in the administration of the trust. The beneficiary may be an individual who may be identified by name, example, John, or by description, example, my son. Beneficiaries may also be specified groups of persons, example, children, grandchildren, nephews, nieces, etc. The beneficiaries may also be known as a class of beneficiaries comprised of the settlor's heirs, meaning anyone who is entitled to inherit property on the settlor's death, or his issue, which is any descendants of the settlor. The beneficiary or class of beneficiaries is the object of the trust, since they are the object of the settlor's wishes.
So we see who the beneficiaries may be. We may have an individual named beneficiary, or we may have them described only as my son, or we may have a group where we put in all children, grandchildren, nephews, nieces. And it can be in a class, so we have them as a class, but we have to make sure that they are what? When we have a class, they should be able to be, what we keep saying, when we have a class of beneficiaries, we have to be able to ascertain.
Ascertain there.
They should be ascertained or ascertainable. Any questions? And what are beneficiaries? The who? What are they of the trust? They are the what? Objects of the trust?
Yes.
Yes. Okay. Go ahead.
The beneficial interest under a trust may be vested or contingent. A vested interest is defined as an interest that the beneficiary has that is either already in his possession or will come to him in the future. If the beneficiary's interest is dependent on the occurrence of a future event, then that event must be certain to happen. Example, the death of another person.
So we have vested and contingent interest. We're now describing the vested interest. So the vested interest is something that is in possession or will come to him in the future. That means that's certain. His interest, if the beneficiary's interest is dependent on the occurrence of a future event, then that event must be certain to happen. But it can't be on something that may not happen. So on the death of someone else, we're certain that somebody will die. But on somebody turning 25, we're not certain they may turn 25. They may die before they turn 25. Okay?
My question is, I guess, if the beneficiary dies, that they're not like a resident of the Bahamas, if there's some high net worth person somewhere in South Africa or Switzerland or whatever, the Inheritance Act of that country would not step in, or because this is a Bahamian trust, Bahamian laws would
Now,
govern.
remember, it go into the beneficiary's estate, not to the beneficiary as a Bahamian beneficiary. So the assets may be in South Africa or they may be in Switzerland. It's not necessarily that the assets are here in the Bahamas. The
Right,
only
but-
thing is that the trust was here, but the assets are somewhere else. Now, what happened is the assets go to this beneficiary wherever his jurisdiction may be.
Mhm.
So it will be probated wherever it is at.
Okay.
Because there may be no assets in the Bahamas to be probated, or this beneficiary may not be a resident of the Bahamas. There's no, so what's the purpose of us probating is a state where we have no jurisdiction? You see, so it will be as if you're trying to probate the estate of someone that is not here. They're not resident here. They have no assets here. So why is it being probated in the Bahamas? It's only probated for the purposes of the trust. So the only thing you can do is to say, I'm probating this estate to say it was a part of a Bahamian trust. But then you'll have to you'll have to reseal the probate in another jurisdiction. So it'll only be to say that all of the assets of this trust or this trust is no longer, because the beneficiary is no longer, we'll say that all of the assets of this trust went to this beneficiary, but that could be probated in another jurisdiction.
Okay, thank you.
The trustee can give their, will just provide information, but it won't be as if they have to be involved after that, because only the beneficiaries now, administrators or their personal representatives will take over. So they'll only call in to realize the assets of the beneficiary's estate. So the trustee will assist them in that instance.
Okay, thank you.
Okay, we could continue.
Under Section 83 of the Trustee Act, beneficiaries are not allowed to obtain information regarding trustees' deliberations in relation to distributions to them. Therefore, beneficiaries cannot demand documents such as minutes of meetings and correspondence between the trustees, particularly those which may specify the trustees' reasons for the exercise or non-exercise of his discretion in a discretionary trust. One primary reason for this prohibition on the right to information is the possibility of a challenge to the trustee's discretion by aggravated beneficiaries.
Okay, so the prohibition and aggrieved beneficiaries. So what rights do the beneficiaries have? They have right to information, and what information they're entitled to receive?
The statement
What
of accounts of the trust.
Statement of accounts. They can, what else they can do?
They can inspect the accounts.
Right. And ask and demand what?
Information and explanations as it relates to those accounts.
When they want copies of the trust accounts, what they have to do?
They have to pay for them.
Right. Now, can they get anything else? Can they get how the trustee made their decisions, the minutes of the trustee deliberations? No. And why they won't be able to receive them?
Because they could use it against them.
Right, so they may challenge the trustee's discretion when they have certain beneficiaries who feel that they should have gotten something more than the other. So this is under section what?
Section 83 of the Trustee Act.
Right of information of the beneficiary. They can obtain information. Okay, go ahead.
Additionally, beneficiaries have the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal action regarding the administration of trust and their duties and obligations to them. It should be noted that Section 23 of the Trustee Act 1998 does allow trustees to insure themselves from the trust fund for legal actions brought against them by beneficiaries, except for breach of trust.
I think that may be section 24 and not 23. So just make that little correction. It may be 24.
Beneficiaries cannot dictate to trustees how they may administer or operate the trust. However, they do have the ability to terminate the trust and compel vesting in the trust under the rule in Saunders versus Vautier. As required by the rule in Saunders versus Vautier, beneficiaries may all be ascertained sub juris of legal age and capacity and in agreement to terminate the trust. The trust fund property is then distributed to the beneficiaries in accordance with the provisions of the trust instrument, even if such distribution is not in accordance with the wishes of the settlor.
Because the letter of wishes is not legally binding, eh?
No, it's not.
That's
Mm.
correct.
No, and now the good thing about section 24 of the Trustee Act is the trustees can insure themselves, eh? For actions brought against them by beneficiaries, except in instances where they are in breach of trust. Because you're gonna have some beneficiaries who want to sue the trustee, eh? So the trustee will insure themselves out of the trust fund to cover themselves. Okay, what interest does the settler have originally before the transfer of property to create a trust? What interest does the settler have before transfer of property to create a trust? We will find that answer.
Is it the legal and equitable titles?
Okay, we will find that. What page?
Page 23.
Okay, page 23. I'm in a different book, so y'all, page 23, what paragraph? 1. So the settler is the person who originally has legal and equitable title to the property and transfer assets into a trust. What other names are given to the settler? We will find that answer.
Grantor and donor, and that's page 23.
And paragraph,
1.
okay. Is a letter of wishes legally binding? We will find that answer.
No, it's not.
Page 23.
Okay, read it for me. Letter of wishes provides practical guidance to the trustee. It is not legally binding and is not required to be followed by a trustee. Number 4, define a power holder under section 18 of the Trustee Amendment Act 2011. Where we'll find that answer.
Page 24. Paragraph
Page
1.
24. Okay. Power holder is any person holding a power in relation to a trust, including a power of appointment, consent, direction, revocation, or variation, and any power to appoint or remove trustees or power holders, and includes a person in the position of a protector. Define a fiduciary, where we'll find that.
Page
Page
24.
24.
And a fiduciary is one.
Who was placed in a position of trust and confidence and acts on behalf of another person or persons.
Awesome. What duties do a fiduciary have to the person for whom he is acting? Where we'll find that answer.
Page 24.
Mhm.
Additionally, the
What
fiduciary
duties does he have?
should act in good faith in relation to the persons or persons.
So he has, okay. So he has loyalty to the person for whom he or she is acting and should act in good faith in relation to the persons for whom he or she is acting. What are the general duties that a trustee owes? Where we'll find that?
Page
Page
25.
25.
And give me 3.
To keep trust accounts, to protect and preserve trust property from unnecessary loss, and to make no secret profit.
Great. Define a vested interest and a contingent interest. Where we'll find that?
Page
Page
26.
26.
Okay. What is a vested interest?
Vested interest is defined as an interest that the beneficiary has that is either already in his possession or will come to him in the future.
Okay. And what is a contingent interest?
A contingent interest is defined as an interest that the beneficiary has that is dependent on an event that is not certain to occur and is not a vested one.
Okay. Number 9, what are the rights of a beneficiary? Where we'll find that?
Page 26.
Okay. Give me some of their rights.
They have a right to inspect trust accounts and demand information and explanations on them.
Mhm.
Oh, keep going.
What else?
Would it be beneficiaries of the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal actions regarding the administration of trust and their duties and obligations to them?
Yes. Okay, and number 10, explain the beneficiary's right to information under Section 83 of the Trustee Act 1998. Where we'll find that answer.
Page 26.
And what it says?
Under Section 83 of the Trustees Act, beneficiaries are not allowed to obtain information regarding trustees' deliberations in relation to distributions to them. Therefore, the beneficiaries cannot demand documents such as minutes or meetings and correspondence between the trustees, particularly those which may specify the trustee's reasons for the exercise or non-exercise of his discretion in a discretionary trust.
Okay, and above, what they say about Section 83?
It gives beneficiaries of Bahamian trusts the right to information under certain specified conditions and in certain specified circumstances.
All right, and who has the exclusive right to sue under the trust?
Beneficiary.
What page that is?
Page 26.
Okay. And that's the beneficiaries have the sole and exclusive right to sue trustees in relation to a breach of trust or any other legal action regarding the administration of the trust and their duties and obligations to them. Okay, do you have any questions on Unit 2? No?
No.
Okay, so we'll move on to Unit 3. Everybody's pretty comfortable with Unit 2?
Yes.
Okay, after reading Unit 3, we should understand the different types of trust, recognize the reasons for the classification of trust, distinguish the features of various types of trust, and understand the benefits of different types of trust. Okay, we have Kendra Jones is up next. Classifications of trust.
Classification of trust. The classification of trust is important to understand the fundamentals of trust and the way in which trust may be used to achieve different objectives by intention or operation of law, depending upon the circumstance. Generally, express trust and presumed resulting trust are created by the express intention of the settlor. Constructive trust and automatic resulting trust arise by the operation of law. Simple and special trust. A simple or bare trust is one that does not impose any active duty on the trustee. The law imposes such duties on the trust. The trustee's duties are not stated. Example, I leave all of my estate to Adam to hold on to trust for Benjamin. However, a special trust states the trustee's duties. Example, $5,000 to Angela on trust to pay the income to Betty or Cindy at her discretion.
So
Statutory.
we see a simple or bare trust. The trustee doesn't have any duties as such. It's just sitting there and he only holding it on trust for somebody else. Or where there's a special trust, it states what he has to do and what else he has to do. Uses discretionary. He's still not doing much more than what the beneficiaries are gonna ask him to do. Yes? You notice it? The difference? Yes?
Yes.
Go ahead.
Statutory trusts. These are created or implied by statute. Example, when a person dies, intestate their property vests in the personal representative. When land is conveyed to persons in undivided shares, it will vest in the first four named persons.
Okay, in that first line, just change the personal representative to the administrator. Instead of personal rep, because they die in intestate and not testate. Testate is the personal representative. Testate means they left a will. Intestate means they didn't leave a will, so they have to have an administrator appointed.
Continue.
Yes.
Express trust. An express trust is one where a settlor makes a declaration that certain property is to be held in trust for certain persons or objects. The terms of an express trust are normally specified in the actual document. The creation of an express private trust requires three main stages: satisfying the three certainties, fulfilling any statutory requirements, and transferring the subject matter to the trust. Express trusts are divided into trusts based on intention and those which arise by operation of law. Read Vanderbilt's trust. Executed and executory trust.
Now we know, before you go on, we know that we were dealing mostly with our express trust, right? That's what we went over in our chapters, where we have different types of express trust, discretionary, non-discretionary, fixed, all of that. And they have to fulfill the certainties in order to satisfy that the trust is properly created. Yes?
Yes.
Okay, go ahead.
Executed and executory trust. These terms refer to the creation of a trust. An executed trust is a trust where all of its terms have been set out so that no further documents are necessary, nor there is any need for the court to determine the intentions of the settlor from words expressed. An executory trust is a trust where the settlor declares an intention to create a trust, but has not explained in detail the precise interests of the beneficiaries. Davis versus Richards and Wallington Industries, 1990. Completely.
So you see the difference with the executed trust? All terms were set out, unlike with the executory trust. It's not set out complete, and therefore we don't know who who's going, which beneficiaries get what? What are their interests? Go ahead.
Completely and incompletely constituted trust. A completely constituted trust is a trust where the settlor, having made his declaration, either declares himself trustee or conveys the property to the trustees in accordance to the familiarities for the transfer of that type of property. Malroy versus Lord, 1862. In instances where it can be proven that the trust was created to defraud a settlor's creditors in some way, or that the settlor did not have the requisite capacity, or the trust was created fraudulently, a trust may be declared void, although it has been completely constituted. An incompletely constituted trust is a trust where no property has been transferred into the trust as it is required by law. In consideration of the nature of such trust, it could be argued that no such trust exists in equity.
Any questions on that one? Okay.
Private and public trust. Express trust created for the benefit of an individual or class of beneficiaries is a private trust. Even though there are categories of purpose trust and charitable trust, an express private trust must be created for identified individuals. A public trust is a trust which is intended to promote the public benefit or public welfare. Such trusts are referred to as charitable trusts.
Any questions on private and public trust? Everybody's clear on them? Okay. Go ahead.
Discretionary and fixed trust. A discretionary trust is a trust where the trustees are given the discretion to make a payment of income or capital both to a certain beneficiary or class of beneficiaries under a trust. Example, $15,000 to Elaine and Monique to pay any or all of the capital and income to such of my children as they shall in their absolute discretion select. A fixed trust is a trust which provides for fixed interest for the beneficiaries. Under a fixed trust, the trustees have no powers to alter or withhold such interest unless required by law. Example, $10,000 to Lane and Monique to hold the capital and income for my children in equal shares.
Okay, so we see where we have a fixed trust where the trustees in this instance, Elaine and Monica, only holding the income and capital for the children in equal shares, unlike in the first example where Elaine and Monica has the $15,000 to pay any or all of the capital and income to such of my children as they shall in their absolute discretion select. So they have discretion in the first one, and the second one is fixed, and they have no discretion. They are supposed to give it to the children in equal shares, and they're only holding it until such time. Go ahead.
Protective trust. Protective trusts are trusts which are created to prevent a beneficiary from disposing of any or all of his beneficial interests. These trusts are designed for spendthrift or wastrel beneficiaries.
So
Example,
that's wastrel.
wastrel beneficiaries. Example, $25,000 to Helen and Mark to hold upon protective trust for Samuel.
So in Samuel's case, Samuel may be a beneficiary who just wastes his money or spends it recklessly. And so Helen and Mark is going to hold a protective trust for Samuel. There's $25,000 to ensure that when Samuel gets the money, it's not going to be for careless or reckless reasons. They will ensure that he's not just recklessly going through $25,000. So they're protective trusts. Okay, go ahead.
Secret trust. A secret trust is one which arises under a will and is intended to provide for an object or purpose without being detected or revealed on the face of the will. There are two types of secret trusts: A, fulfilling secret trust, and B, half secret trust. A fulfilling secret trust. It will appear in the will as an absolute gift, and the beneficiary under the will is informed of the trust outside of the will. It does not appear on the face of the will. The testator, having told the legality of the purpose of the trust outside of the will, the testator must communicate the fact that the property is to be subject to a fully secret trust to the legatee under the will. The communication must be made at any time during the testator's lifetime. It is irrelevant whether the fully secret trust was made known to the legatee before or after the date of the will. Walgrave versus Tebbs, 1855. The testator must communicate a legally binding obligation and not a moral obligation. McCormick versus Krogan, 1869. All terms of the trust must be communicated, that is, the property and beneficiaries. The legatee must accept the fully secret trust.
In order for the fully secret trust to be recognized, the legatee must be informed of the purpose of the trust outside of the will, and he must accept that it's a fully secret trust.
Have secret
Go
trust.
ahead.
Have secret trust. It will appear as a trust in the will, but the details are revealed outside the will. The conditions to be met for a have secret trust are the testator must communicate the have secret trust to the legatee before or contemporaneously with the making of the will. Blackwell versus Blackwell, 1929. Similar to a fully secret trust, all the terms must be communicated and it must be legally binding obligation.
Okay, we get what is a half secret and a fully secret trust. Okay, Donika said not. Okay, so the fully secret trust. So where this will appear in the will as an absolute gift. And the beneficiary under the will is informed of the trust outside of the will. So as much as we'd establish fully secret trusts, for what purpose you think? We have, why wouldn't we want someone to know who we're leaving something for? In instance of a settler leaving property for somebody or leaving gifts for someone, that may be an outside family, that their family doesn't know about. And so they want to ensure that there's no backlash. They may be in a civil law jurisdiction where they have forced their ship rules, and they may not be able to leave things outside of their family for outsiders that are not a part of the family. So it may even be against their ship laws. So they create this secret trust. They will inform the legatee that I have created a trust outside of the will. So it's an absolute gift in the will. The beneficiary is informed outside of the trust outside. So it'll be, I leave all of my assets to ABC Trust. Nobody knows who's the beneficiary of ABC Trust, eh? So that's the secret of it. They only know that it's a trust who holds that asset. And from that point on, nobody can you come and ask me who's a beneficiary of any of a trust? If I don't have the beneficiary's name, is the trust information out there? Does anybody could just access it?
No.
No.
Right, so on my death, I leave it for a trust to a trustee, and the beneficiaries remain secret, but they know who they are because I tell them before I die, or I tell them during my lifetime, I'm creating a trust. You can contact this person upon my death, and they will have something for you. Whereas the half secret trust, they reveal it outside of the will. and there are conditions to be met. They must communicate they must communicate it to the levity before or at the same time of making the will. In order for it to be legally binding, the terms must be communicated. So I've told you that this is not to be disclosed outside of the relationship. So the purpose of the secret trust is usually for things that I can't just give out right without me drawing suspicion. So usually people do that. Settlers would usually set up secret trusts for their family members or for a mistress or something outside of their relation. Is it any clearer? Okay. Okay, charitable trust we'll give somebody else now. Who's next? Shanice, who just read?
I just read.
Okay, so it's Christeria. Christeria, is your mic working? Maybe not. Shanice, is your mic working?
Yes.
Okay, you didn't read yet, eh, Shanice?
No, not as yet.
Okay, you can go ahead with charitable trust first, please.
Okay. A charitable trust is a trust which is created to promote a charitable purpose by benefiting the community in some way. They are known as public trusts and are enforceable by the Attorney General on behalf of the state. A charitable trust is different from a private trust, which seeks to benefit defined persons or a narrower section of the public. Charitable trusts have certain privileges, such as certainty of objects, the perpetuity rule, and fiscal privileges. A charitable trust will not fail for uncertainty of objects. However, to qualify as a charitable trust, the trust must be exclusively for charitable purposes. Charitable trusts are not subject to the rule against perpetual trust, but they are subject to rule against remoteness of vesting. That is, if a charitable gift is contingent upon the happening of a future uncertain event, it will be void if there is a possibility that the gift may vest outside the perpetuity period of a life or lives in being and 21 years. Additionally, most charitable trusts are exempt from income tax. The original list of purposes was accepted in the preamble to the Statute of Elizabeth, 1601. The relief of aged, impotent, and poor people, the maintenance of sick and maimed soldiers and sailors, the maintenance of schools of learning, free schools, and scholars in universities, the repair of bridges, ports, churches, and highways, the education of orphans, the support of young tradesmen, handicapped men, and persons decayed, and the relief of redemption of prisoners or captives. However, the modern classification was propounded in the case of Commissioners of Income Tax versus PEMSO. There are 4 categories of charitable trust. 1, for the relief of poverty. 2, for the advancement of education. 3, for the advancement of religion. 4, for other purposes beneficial to the community, which come within the spirit of the preamble.
Okay, so charitable trust, you could think of any charitable trust that you may know that's a public trust that.
Public.
Maybe Life Key Foundation, no? That's not a
There's a
trust.
foundation, so it's similar, but
Similar.
what else they have?
Bahamas Trust?
Bahamas National Trust,
Oh, yeah, okay.
because that's a
Mhm.
purpose beneficial to the community,
Correct.
The Red Cross don't have a trust, but usually people include them because they relieve poverty, right?
Right.
So we see now, notwithstanding they set up these charitable trusts, sometimes people still benefit as a result of them setting up these trusts. They use it for tax purposes and other things that may help them. So not only I'm just going to set up the trust, but it will benefit me in some way as well, because they still profit sometimes from these things, eh?
So question,
Okay.
like in the case of the National Trust, so the trust is set up where other persons can still make contributions or
Right, so they make,
ask
so people are always
or
making
expand it?
contributions to the National Trust, eh? They even get government subvention sometimes. They may get property because they're preserving certain things. So they now become very, they're asset rich, eh, on paper. Because now they say certain areas are protected. You know, they have that Exoma, what is it, Land and Sea Park? That's under their protection. So they now are responsible for certain things. So now they should get donations from people to help preserving it. They usually have a big festival every year to raise funds. And they have people donating to them all the time, eh?
So essentially the original trust that was formed was depleted, but because persons continue to make contributions to the trust, that's what the reason why the trust is still able to be in existence.
But I mean, what's the purpose? Remember, it's not, the rules of perpetuity won't apply in this instance, eh? What we just read, what they say about the perpetuity period. So it continues to exist because it's set out for the public. It's not a private trust. It's for the public. Do we have to ascertain who are the objects? Will it fail for certainty if we don't have objects?
No.
Because it's for the public at large, yes?
Yes.
So it's not a typical trust where you need to have certainty of objects. It has to fall within the years and beings and all that. But it now is for public, and it's for the advancement of any of these four categories, eh? Relief of poverty, advancement of education, religion, or purposes beneficial to the community. So in the instance of the National Trust, what benefit do they pose to the community?
I guess protecting natural resources
Right. So
for
they
future
protect-
generations.
Right, so they protecting and preserving our resources for those yet born. And it helps us all around because then all of our sea life would be wiped out if they don't, like that Exoma Land and Sea Park is pretty important to the National Trust. Then they have the pond over here on the highway. I think it's the Bonefish Pond. I'm not sure what's the name of it. But they have adopted certain areas and they are keeping them from human intervention, more or less, where they just park up the land and then build something over it. Because these things have to be preserved unless we lose our ecosystem soon, basically. And we would be in trouble when they realize it'll be too late. So these people set up a trust to save us from ourselves. And so the contributions, the corpus has been set up, but now you also have people who are able to now donate because it's a charitable trust, eh? So instead of them investing or having investments, they have people who will donate. They may have people who pay admission fees to come to these or to look at the land and see park or go to the events. So that will always add to the trust property. But in the meantime, they already set the groundwork, and it's a public trust. Any other questions? We still here? Everybody still here? Y'all
Yes.
can hear me?
Yes, ma'am.
Okay,
Yes, we're here.
let's go on to the next one.
Am I still reading?
Yes, please.
Okay. Purpose trust. A purpose trust is a private trust which is intended to benefit purposes rather than beneficiaries. As a general rule, such trusts are void. However, there are exceptions. R.E. Endicott, 1960, Chapter 232. In some instances, trusts which fail to be treated as purpose trusts arise, as they are seen as failed attempts to create charitable trusts. See also Section 39 of the Trustee Act.
So the purpose trust may be set up for some charitable purpose or non-charitable purpose. And they usually set it up, again, that's a trust which advances some purpose, or they can set it up for a tax purpose, because usually people set it up to say, well, after I would have completed this is only set up to do a certain thing, and when that's done, then the trust is completed. Yes? You all are clear on the
Yes.
purpose trust?
Yes, ma'am.
Okay. Okay, go ahead.
Implied and resulting trusts. Resulting trusts arise from the presumed intention of the settlor, particularly in instances where he has failed to express his intention clearly. R.E. Van der Velde's Trust, number 2, 1974, Chapter 269. An implied or resulting trust would arise if a settlor created a trust of $300,000 for a life. Equity would presume that he intended the money should result to himself or to his estate on Amos's death. R.E. Abbott, 1902, Chapter 326.
Okay, so you understand what they're saying? An implied or resulting trust would arise if the settler created a trust of $300,000 for the life of Amos. So when Amos dies, they presume that he intended the money should result back to himself or his estate if Amos dies before the 300,000 is depleted. So in the case where I don't remember, someone asked about a beneficiary. Suppose they created a trust for beneficiaries. If it's absolutely for the beneficiary, on his death, it goes on to his estate. But if it's only for his lifetime, then it results back to the settlor. Yes?
So it only reverts back to the settler for implied trusts.
Where the settlor has it's not fully vested in the beneficiary. So it's only for the life of the beneficiary. So I'm married to someone and I say she can stay in the house, even though it's my house, it's her house for her life. So it's only for her to benefit during her lifetime. It's not an absolute gift. She doesn't get it. If she dies, it doesn't go on to her estate. It reverts back to the original owner.
To the settler. Reverts
Yes.
back to the settler. Okay, thank you.
Okay.
A presumed resulting trust may arise where two or more parties have purchased property jointly or in the name of one person and have contributed in different proportions. there will be an implied understanding that all parties will have an equitable interest in the property. Gissing versus Gissing, 1971, AC 886. Or where in the absence of evidence, the party's intention, the voluntary transfer of property from Amy to Candy, can in some circumstances give rise to a presumed trust where Candy is deemed to hold the property in favor of Amy.
So where I voluntarily transfer property from Amy to Candy, it is presumed that Candy is only holding the property for my benefit. I didn't get any consideration for it. I just transferred it over to her. So that's similar with resulting trust. We'll go on to that, where it operates on the operation of the law. Go ahead.
An automatic resulting trust arises by operation of law, notwithstanding the intention of the settlor or parties. This may arise where a disposition is made by Amy to Candy on trust which leaves some or all of the beneficial interest undisposed of. Candy will hold the undisposed of beneficial interests automatically on a resulting trust for Amy. Note that a resulting trust will not arise where a transaction fails to make any effective disposition of any interest. For example, where property is disposed of by writing as opposed to a deed.
So the resulting trust automatically happens by operation of the law, notwithstanding the intention of the parties. So where Amy gives to Candy some things that are undisposed of, some beneficial interests that are not undisposed of, Candy will only hold the undisposed of beneficial interests automatically on a resulting trust. The property that are disposed of will not result to Amy. So it will not go back to Amy because it was disposed of. Undisposed beneficial interest will revert back to Amy. Likewise, where you would have disposed of property in writing instead of by a deed, it will not fail because you didn't do it properly, and it will not result back to Amy. It'll stay with Candy, and by the operation of law, they'll try to correct it to say the intention was there, that it should have been passed on. Okay?
Okay. A quist-closed trust, which is a trust where a person or entity transfers property or funds to another person or entity for a specific purpose, which creates a trust relationship between the two parties, is an example of an automatic resulting trust.
Okay, so I just transferred, I gave you $1,000 to hold, to pay for certain things. You didn't, you've paid for the items, and the undisposed of $800, you may only use 200, that reverts to me. That's automatically my own because it was set up for a particular purpose, eh? And so the result of it is I get back automatically by operation of the law. I didn't intend for you to keep my money. I gave you that money to do something, and if you've completed the purpose, the balance of the funds is reverted to me. Claire? Go ahead.
Constructive trusts. Constructive trusts are trusts which are imposed by operation of law by the courts as remedies where the conduct of a party makes it unjust that he should maintain the whole or part of the beneficial interest in certain property for himself. Constructive trusts are imposed irrespective of intention, either express or implied, of those affected by it. A constructive trust appears to be to preserve property rights affected by unconscionable conduct on persons considered to be constructive trustee. A constructive trust will be imposed on a fiduciary who tries to make a secret profit from his fiduciary position. Keach versus Sanford, 1726, 2 EQ Cass 741. In the case of Boardman versus Phipps, 1967, 2 AC 46, demonstrated the following example of a constructive trust. If Mr. Bethel, a trustee, wrongly took 1,000 shares in Milkstand Co. from the trust for himself and bought 1,000 shares in Yellow Company for himself when they were offered to him for the benefit of the trust, he would be a constructive trustee of all shares for the benefit of the beneficiaries of the trust.
So what happens in what you understand a constructive trustee as? We draw an example where if they were offering me a property, I bid 10,000 on it on behalf of beneficiaries of a trust, me as the trustee. The trust, the beneficiaries were interested in purchasing a property. It was 10, I bid 10,000, and me as the trustee go ahead and bid 11,000. Conflicting. What happens with me secretly profiting if I don't disclose that? What happens with that property? I become constructive trustee, eh?
Right, by the courts, right?
You become constructive trustee, yes, for the benefit of the trust, because you would have used your what? You would have allowed your personal interest to conflict with your duty, right? In the case of Boardman and Phipps, what happened? The trustee took 1,000 shares from the trust, which was in Milkstand Company, and then he additionally bought 1,000 shares in Yellowstone, which were offered to him for the trust. They were not offered to him personally. He took them and he purchased them. So he was held to be constructive trustee for all of the shares, both Milkstand and Yellowstone, for the benefit of the beneficiaries of the trust. So notwithstanding, he took his money and bought Yellow Company shares. Those shares were also now considered, he was the constructive trustee of those shares for the benefit of the beneficiaries of the trust. You understand?
Yes, I think I understand, yeah.
Okay. Go ahead.
Constructive trustees are not subject to the same duties as an express trustee, nor do they possess any powers as a trustee. By imposing a constructive trust, the aim is to recover trust property from the trustee, trace the proceeds of the property of the trustee if the trustee has disposed of it, or bring a personal action against the constructive trustee.
Okay, so that means that notwithstanding he's being held to be a constructive trustee, it's not for him to hold the shares in trust for the beneficiaries. It's for them to recover the shares from him for the benefit of the trustee, for the trust. And he's no longer, he'll be removed, eh? The court will now remove him as trustee because he is in breach, eh? Yes?
Yes.
Yes,
You
ma'am.
understand that, or it's not clear?
Yes, ma'am, we understand.
Okay. All right, next Sham Trust, we'll go with Tanisha Knowles.
A sham trust is a trust document which is not a trust. The trust may have been constituted in the sense that the trustees may be in possession of intended trust assets and there may be a signed declaration or settlement. However, At the inception, there is no trust because the actions of the parties demonstrate a nominee or agency arrangement. The trust is incompletely or improperly constituted, or the actions of the settlor and/or trustees negate the existence of a trust. Example, Raman case. In the Raman case, the settlor's behavior in aggressively and unilaterally dealing with trust assets and investments as he pleased, and the trustee's behavior in allowing him to act in such a manner, subsequent to the creation of the trust, led the court to decide that the trust was a sham, as the evidence proved that there was no clear intention for the trust to operate as a trust, but rather as an agency or nominee arrangement.
So in this case, in the Raman case, the settlor was acting as if the trustee was only his agent and he still had all of the powers, or he still had all the ownership of the trust property, eh? So in that instance, it is from this inception, there's no trust because the actions of the parties demonstrate a nominee or agency arrangement. So where that's the case, where the settlor still has power, you can't say that he's no longer part of the trust. He's still operating as if the assets are still his own, and the trustee is merely a puppet for him, eh? Go ahead.
The Sham Doctrine, which most common law jurisdictions adopt, was enunciated by Lord Justice Diplock in his statement in Snook versus London and West Riding, 1967, 2 QB 786 at 802. Do you want me to read the little excerpt?
Yes, please.
Okay. I apprehend that if it has any meaning in law, a sham means act done or documents executed by the parties to the sham, which are intended by them to give to the third parties or to the court for appearance of creating between the parties legal rights and obligations different from the actual legal rights and obligations, if any, which the parties intend to create. The one thing I think is clear in legal principle, morality, and the authorities is that for acts or documents to be a sham, with whatever legal consequences follow from this, all the parties thereto must have a common intention that the acts or documents are not to create the legal rights and obligations which they give the appearance of creating. No unexpressed intentions of a shammer affect the rights of a party whom he deceived. It
So
was
that's basically it in a nutshell, what they consider the Sham Doctrine. They only intend to give the appearance that there was a trust set up, but really and truly, they were only trying to avoid or defraud somebody else from getting to things that they should be able to get. So I took a loan out, I got the funds, and never intend to pay the funds back. I invest the money into a trust. And I have full carriage of the funds, but I put it there as if the trustee's in charge, but I'm telling the trustee what to do. Go pay my light bill, go pay this, go do the next thing. And then the bank comes after me. I say, I don't have anything, but the bank finds out that I created a trust and they can see that I'm still in charge of the funds that I would have gotten from them. They can now go behind it to say that this trust was only set up as a sham to avoid paying his creditors. So he's deceived the bank, and those who in the general public may think that this is actually a trust set up for that purpose. Go ahead.
It was also stated that the conceptual basis for the sham doctrine lies in the court's ability to see through acts or documents which are intended as a facade or disguise designed to conceal the real truth of the matter by settlers, trustees, and/or their advisors, particularly in offshore revocable trusts, which are susceptible to legal scrutiny when it comes to sham trusts. Courts will often review and analyze the subjective intentions of the parties to a trust transaction. One of the key elements in their analysis is to determine whether all the parties to the transaction had their requisite intention to mislead third parties. Additionally, courts will scrutinize the conduct of the parties, particularly the settler's retention of certain powers and his control and dominance over the decision-making and actions of the trustees and the trust assets. In the Raman case, Mr. Raman retained control over the trust funds during his lifetime. Consequently, it was held by the Jersey court that the trust was a sham, particularly since the trustee was never made master of the assets. However, it must be noted that in bringing cases involving purported sham trusts, that the onus of establishing whether a sham exists rests on the party asserting that the transaction is a sham. Example, equitable maxim, he who asserts must prove. Therefore, it is the challenge of the plaintiffs in the trust litigation cases to prove that a trust is a sham when commencing action against trustees of offshore trusts. The standard of proof is the civil standard, example on the balance of probabilities.
So notwithstanding, because I bring a case against you to say that this only a sham that's set up, I must prove my case. I can't, I am saying that you did it, so I must prove it. The equitable maxim, you asserts must prove, will stand in, and you must show how you come to believe, or you must have evidence to show that the settler is doing this. The trustee is really just sitting there. The trustee was never made master of the assets of the trust. The settler always had control. Because in the Raman case, what happened? The settler retained what? What the settler did in the Raman case?
He was still the master of the assets.
Right, so he retained control over the trust funds during his lifetime. And the standard of proof is the civil standard on the balance of probabilities that this actually happened. So trust is distinguished from other relationships. We might as well let you finish it off for us, please.
I do not see that.
Y'all don't have that? Oh, that was earlier. This may be a reprint because I have a different book from y'all. What is your name? That's it?
Yeah, after that, it says, it's the self-assessment questions.
Okay. All right, because my book has a little difference. Okay, define and express trust. You all have that as question, right?
Yes.
Yes, ma'am.
Express trust.
We will find that answer.
Page 29.
Statutory
Okay, what is an express
requirements.
trust?
I only know two, statutory requirements and transferring the subject matter. I don't know what's the third one.
No, define the express trust. Where we'd find that?
Page 29.
Okay, tell me what it is.
An express trust is one where a settler makes a declaration that certain property is to be held in trust for certain persons or objects.
Okay, define a simple or bare trust. Where we'll find that?
Page 29.
What is it?
A simple or bare trust is one that does not impose any active duty on the trustee.
Okay. Define executed and executory trusts.
Page 30.
Okay,
An
what is an
executed
executed
trust is a trust where all of its terms have been set out so that no further documents are necessary, nor is there any need for the court to determine the intentions of the settler from words expressed.
Okay, and what is the executory trust?
A trust where the settler declares an intention to create a trust but has not explained in detail the precise interests of the beneficiaries.
Okay. Define completely and incompletely constituted trusts. We will find that.
Page 30. A completely constituted trust is a trust
Okay,
where the
what is a
settlor.
completely considered trust?
A completely constituted trust is a trust where the settlor, having made his declaration, either declares himself trustee or conveys the property to the trustees in accordance to the formalities for the transfer of that type of property.
And completely?
Is a constituted trust is a trust where no property has been transferred into the trust, as is required by law.
Okay, explain the difference between a discretionary and a fixed trust.
Page 31. A discretionary trust is a trust where the trustees are given the discretion to make a payment of income or capital or both to a certain beneficiary or class of beneficiaries under a trust, whereas a fixed trust is a trust which provides for fixed interest for the beneficiaries. Under a fixed
Okay.
trust, the trustees have no powers to alter or withhold such interest unless required by the law.
Awesome. Define a protective trust.
Protective trusts are trusts which are created to prevent a beneficiary from disposing of any or all of his beneficial interests.
Okay, we will find that one.
Right under discretionary and fixed on page 31.
Awesome. Okay, define a half secret trust.
A half-secret trust, it will appear as a trust in the will, but the details are revealed outside the will.
Okay, and where we'll find that answer.
Page 31, last paragraph.
Okay, what is a resulting trust?
Page 33. A resulting trust arises from the presumed intention of the settler, particularly in instances where he has failed to express his intention clearly.
Okay. Explain the difference between a charitable and a private trust.
A charitable trust is created to promote a charitable purpose by benefiting the community in some way, whereas a private trust. Oh, I lost the other one, sorry.
Private trust under the purpose trust.
Oh, whereas a private trust is intended to benefit purpose rather than beneficiaries.
It's a private trust intended to benefit, and we have private trust in where again? Express trust. So it's created for the benefit of an individual or class of beneficiaries. We have that in private and public trust on page 27. You see where we have private and public trust, well, that's not 27, that's your page 29A.
Page 30.
Okay, 30. You see where we have private and public trust? So we have
Yes, I see.
different types of private trust, eh? They could be purpose, charitable, or express. Okay, everybody got the charitable and private difference? The charitable trust is made for what benefit?
The community.
And these are for individuals more than, or for purpose, for a particular purpose, eh?
Yes.
All right, define a constructive trust.
Constructive trusts are trusts which are imposed by operation of law by the courts as remedies where the conduct of a party makes it unjust that he should maintain the whole or part of the beneficial interest in certain property for himself.
Where we'll find that?
Page 33.
Okay. and explain a sham trust.
Basically a document that's not really a trust, whereas the settler still has power and the trustee is more so the puppet.
And he's just acting as a nominee or an H&A. Where we'll find that answer with page.
34.
All right, so we have gone over any questions on this chapter. Hello?
Yeah, I have a quick question
Okay.
in regards to the revocable trust. I think it was saying, I don't have a book, so I just go by based on what I
What
thought
you
I heard.
Okay.
I think that it was a prerequisite to mislead, and the settler is maintaining control over the assets, right?
Mhm.
Can support, you can, based on my understanding thus far, it seems like it all depends on how you set up the trust. Can you also set up the trust for the settler to maintain control? Can it be a legal thing? Where
Where,
he's
but
still
what
able
we
to,
say, what the settler could reserve powers to him by which section?
like as a protector, can a settler also be like a protector? Yeah, that's my
Yeah,
question.
and what we say, would he be a power holder? Or he could
Right.
certain powers to himself under what section of the Trustee Act? Anybody?
Not 28.
Was it 24?
20.
No,
Or
24 is
28?
insurance. Remember we talked about him reserving some powers?
Right.
That 18?
Hmm? And unit 2, that's what we began
Yeah.
with.
Yeah, you say the settler can act as a protector. I answered my own question. Right?
No, when we talking about him reserving powers to himself, where it won't be considered that he's doing something untoward. We say that's the first page on unit 2.
Oh, section 3.
Section 3, yes, he can reserve powers to himself, or he can appoint himself, he can be appointed as a power holder under section what? Where it's a settler directed trust. The section,
13?
what is it?
Is it 13?
Yes, 13 of the TAA. And this will be under settler directed trust, because the power holder is defined under what section of the Trustee Act? We have
18?
four. What is it?
18?
Yes, 18. So they put these provisions in to avoid it being called a sham in these instances, and where the settler may still want to maintain some control,
Mm-hmm.
they've made provisions in the law to cover that.
Okay.
So it has to be where it's totally seen as it's a sham from the beginning. But once these things are in place, it helps, but that doesn't mean it's foolproof from them not still finding it to be. He's the master of the assets and not the trustee. So it would have to be in circumstances, and the settler should know, basically based on the initial meeting with the trustee, and them getting the whole gambit of what the settler owns and what he's up against, because usually these are trusts for the preservation of assets and for succession planning. So they would want to be upfront with the trustee in order for the trustee to set up a trust that would be beneficial to them. So if they just come and say, oh, I still want to maintain control, the trustee has to ask them certain questions whilst you're maintaining control, what is it, why you want to maintain control? Why don't you, they should give them options where because they must advise them that they could be subject to scrutiny by people saying that they still have full control over the assets of the trust. But basically, because you would understand all the concepts involved, what could be considered sham trust, you would be able as a professional trustee or administrator to say, we have certain cases that demonstrate you may be considered as, we may be considered only an agent if certain things are not in place. So we'd suggest that first of all, you reserve those powers, and then we won't be liable for your investments because you may be a trader. You have more knowledge than us of investments, and you may not be comfortable that we delegate these duties out to somebody else, and you feel that you're the person who can do it, but you just want to make sure that you're protected. So I'm out there and I'm subject to a lot of lawsuits. I want to protect my assets, but I still want to have some control in dealing with the assets. I don't want to give total control over to the trustee, so the Trustee Act makes provisions for me to be able to do so. Any other questions?
No, ma'am.
Everything is clear? We remember what Boardman and Phipps tells us? What principle comes from Boardman and Phipps?
Is that the constructive trust?
Yeah, so where the trustee uses his position, he may become to advance himself and get assets as a result of being a trustee. His assets may be considered those assets. He may become a constructive trustee for the benefit of the beneficiaries of the trust. What Keach Sanford tells us.
A constructive trust will be imposed on a fiduciary who tries to make a secret profit from his fiduciary position.
Right, so where the trustee as a fiduciary makes a secret profit, he becomes constructive trustee of the secret profit for the benefit of the beneficiaries of the trust. That's what the Rahman case deals with.
The Sham Trust.
Right, where what happened in that? The settler was always what?
The settler was always in control of his assets.
Trust fund, right? From the beginning. And what were you saying about the rule in Sanders and Vardier? What rule in Sanders and Vardier deals with? Termination of the trust. Where the beneficiaries, once they are of legal age and sound mind and legally entitled to trust the legal and the equitable interest in the trust, they can terminate the trust.
Yes.
Okay, what about a protective trust? Why would I set up a protective trust?
To prevent a beneficiary from disposing of any or all of his beneficial interests.
Right, because he may be what?
Wasteful or spendthrift.
Yes. All right, and who are the parties to a trust?
The beneficiary, the trustee, and the settler.
Okay, why would I set up a secret trust?
Parties outside of the, I guess, family or relationship.
Yes, I may not want my family to know about my child outside of the marriage. Or I may have laws that prevent me from giving away things that is not in accordance with the laws of the land. All right, any questions?
Yeah, for the test, right? Will we have to know like the sections of the legislation or these case laws?
So the principles derived from the cases help you. The trust law principles derive from the cases as well. So you would find that you can marry those, and it helps you in answering your questions as well much easily. You wouldn't have to be going all over the place because you could just directly say, you would say, Johnny wants to get some information from the trust. He's asking to see the minutes. So you could say, basically, whilst Johnny is a beneficiary of the trust, section, what helps me with beneficiaries' right?
Section 83 of the Trustees Act.
Section 83, entitled to information, but that information is limited to what?
The trustees' deliberations in relation to distributions of them.
Right, but he is not entitled to the trustee deliberation because he could bring a challenge to the trust as an aggrieved beneficiary where he feels the trustee has made a decision that's not fair to him as compared to another beneficiary. We have all that in there.
Right.
Right, and then I'll say, well, suppose I say if the trustee, ABC Trust Company as trustee of the Joey Trust has taken information gained from trust portfolio and they've made a profit as a result of that. What I'll say, what you could say, basically, ABC Trust Company is what? Not entitled to make a secret profits in accordance with what case?
Is that Boardman versus Phillips? I'm not sure.
Boardman
It's constructive.
secret profit is what? Because Boardman and Phipps will come afterward, Keach and Sanford.
Oh yeah, okay.
So he'll become a constructive trustee of the secret profit as also set out in
Keach versus Sanford, 1726.
Right, he can't do that, but Boardman and Phipps also tells us he'll become constructive trustee of the trust for the benefit of the trust. Where he
All share to the benefit of the beneficiaries of the trust.
So you see how it helps you when you answer the questions? Yes?
It does.
Yeah. Any other questions? So it's always good for you to read, look over the cases, or if you're not going to read it, just see what the principles are that are derived from it in your study resource list. Because if you are not able to read the whole case, just look to see what principle is being derived from it, because it's set out in brackets where the principle comes from. So read Watson. They said under common law, beneficiaries are not entitled to demand copies of trust accounts unless they are prepared to pay for them, as set out in the case of Ree Watson. That's simple. You don't even have to read Ree Watson. You know, Ree Watson tells you that beneficiaries cannot get the trust accounts unless they're prepared to pay for it. Passing Greens also tells you that they have a right to information regarding the production and receipt of trust accounts as and when requested by the beneficiaries. Passing Greens tells you that, as well as Section 83 of the Trustee Act. So you see how you can apply it?
Yeah.
And then if I say the trustee wants to purchase insurance for potential suits that may come against them for breach of trust, you will direct me to what section of the Trustee Act to have them to do that?
Section 24.
So you see why it's good to know these things. Because you are answering the question, but you have to show that you understand what laws, because you can't just know it on your own. It has to have been from you gathering information from somewhere. And that's the purpose of you doing the little questions and reading the text properly. Okay?
Yes, ma'am.
All right, so next week, I guess y'all are on the list. So we'll just start at 9 o'clock next week. I will just use Miguel's link instead of using the link I have, because that's set at a recurring meeting at 10, okay? So next week at 10, hopefully y'all could at least read Unit 4, so we'll go through it quickly and go over any questions and review. Just do a quick review of the other chapters if you want to. On any
Okay.
questions, okay?
Okay.
Okay, thank you so much.
Afternoon.
Thank you. Good afternoon.
Good afternoon.
Take care.